Hello and welcome to this Federalist Society webinar. This afternoon, July 5th, 2022, we discuss Courthouse Steps Decisions, Egbert v. Boulay. My name is Ryan Lacey and I'm an Assistant Director of Practice Groups at the Federalist Society. As always, please note that all expressions of opinion are those of our experts on today's program. Today, we are fortunate to have an excellent panel moderated by Marc Levin, whom I'll introduce very briefly, though much more could be said. Marc A. Levin is Chief Policy Counsel for the Council on Criminal Justice and Senior Advisor on the Right on Crime. Marc received his bachelor's from the University of Texas and his JD from the University of Texas School of Law. He served as a law clerk to Judge Will Garwood on the U.S. Court of Appeals for the Fifth Circuit and staff attorney for the Texas Supreme Court. After our speakers give their remarks, we will turn to you, the audience, for questions. If you have a question, please enter it into the Q&A feature at the bottom of your screen, and we will handle questions as we can towards the end of today's program. With that, thank you for being with us today. Marc, the floor is yours.
Well, thank you for having me. I'm really appreciative of the Federalist Society for convening this discussion. There's been, of course, a lot of controversial Supreme Court cases in recent days, and this one could have gotten lost to the shuffle, but it's really too important for that to occur. I'll provide a summary of this case in a few minutes, but first I want to just briefly introduce our distinguished panelists who filed amicus briefs on opposing sides of this case, which I think will make for a very stimulating discussion. First, Anya Bidwell is an attorney with the Institute for Justice, and she's one of the leaders in our project on immunity and accountability, which works to promote judicial engagement and hold government officials accountable when they violate the rights of individuals. Before she joined IJ, she was with a top national law firm, and like me, she earned her JD with honors from the University of Texas. Interestingly enough, Anya spent her childhood in Ukraine, which certainly is very notable given the outrageous war that we're witnessing there today. But her work's been featured in numerous publications, including the Washington Post, the Wall Street Journal, and the New York Times. I'm also really pleased that we're joined by John Masslon, who's Senior Litigation Counsel at the Washington Legal Foundation. He previously served as Assistant Solicitor General for the state of West Virginia, where he regularly practiced before both state and federal appellate courts. He has extensive experience clerking for judges, including on the U.S. District Court for the Western District of Pennsylvania and the Superior Court of Pennsylvania. He graduated magna cum laude from Clemson University and went on to receive his JD and LLM in taxation from Georgetown University Law Center. So with that, let me just attempt to give a brief summary of the rather colorful facts of Egbert versus Boulay. I hope I'm pronouncing that right. But this deals with excessive force, First Amendment retaliation, and also in the context of our border, although not the one with Mexico, but with Canada. And what essentially happened here is Robert Boulay is a U.S. citizen. He owns and runs a motel called the Smuggler's Inn, which is a bed and breakfast that abuts the Canadian border in Blaine, Washington. He actually drives a car with a smuggler license plate and worked as a confidential informant for the Customs and Border Patrol. So I'm not exactly sure how this all unfolded, but it's quite, I guess, unusual, perhaps. But the petitioner, Eric Egbert, is a Border Patrol agent, and he attempted to speak with a guest who had just arrived from Turkey through New York. This guest was entering the inn and was still outside the inn. And Boulay asked Egbert, this FBI agent, to leave, or Border Patrol agent, rather. Boulay, this innkeeper, asked Egbert, the border agent, to leave his property. And he attempted, and then when he did so, Egbert shoved him to the ground. Boulay did complain to Egbert's superiors at Customs and Border Control, which ends up being kind of relevant because the majority says there's administrative remedies through the agency, although that would only lead to discipline potentially of the agent, not any damages. But Egbert, and this is a key part of this is where the retaliation claim comes in. Egbert allegedly contacted the Internal Revenue Service and state agencies, which actually resulted in a tax audit and investigation of Boulay's activities. So we ended up with a majority opinion. It was a 6-3 decision, and basically distinguished this case from Bivens, the decision back in the early 70s regarding sovereign immunity, and in fact held that Boulay is not able to proceed with any of his claims. So I think our speakers here are much more equipped than I am to go into more detail about this holding as well as the implications going forward. I have a few questions that I'll pose, but I hope those folks tuning in live will also give thought to their questions. So who would like to go first?
I'm happy to go first.
Great.
All right. Thank you very much for having me. It is an honor to be on, and I'm very, very happy that you are discussing this indeed very important decision. And I have several takeaways from it. First, in Egbert, the United States Supreme Court all but overturned Bivens without explicitly doing so. It essentially now has this new test, and the test is if there is a rational reason to think that Congress is better equipped to weigh the costs and benefits of providing a damages remedy, as it will be in most every case, says Justice Thomas, no Bivens action may lie. And then we have Justice Gorsuch in his concurrence basically saying, if the costs and benefits do not justify a new Bivens action on facts so analogous to Bivens itself, right? Here, you basically have a Fourth Amendment violation coming onto property and exercising excessive force, very, very similar to Bivens. So Gorsuch says, if on facts so analogous to Bivens, we can't recognize Bivens, it is hard to see how we can ever recognize Bivens. In addition to the Egbert decision, there were two petitions involving domestic policing that were pending, and the court held them pending the Egbert decision. And those two petitions with domestic policing not having anything to do with the border were denied, and the Fifth and Eighth Circuit's decisions that denied Bivens cause of action on facts very similar to Bivens were left in place. So as far as I can tell, with Egbert announcing this very stringent one-part test, and with Byrd, the Fifth Circuit decision, and Mohammed, the Eighth Circuit decision, allowed in place, it is very difficult to see how federal officials are entitled to anything other than absolute immunity. But because there is no explicit overturning of this precedent, in Justice Gorsuch's words, the court is still holding out false hope and providing Congress, frankly, with plausible deniability to not amend Section 1983. So that is problematic. So I obviously want Bivens to be robustly enforced, but if it isn't, if it's being overturned then it at least needs to be explicitly overturned. So there is certainty going forward. So that's kind of my takeaways from the Egbert decision itself, but I do want to talk about big picture, right? Why is it so important for courts to enforce the Constitution? The Bill of Rights is an anti-majoritarian document. It really makes very little sense to entrust Congress, an institution that's beholden to the majorities, with enforcing this anti-majoritarian document. So how do you get courts to do their job, right? One option is really for state courts to do it, common law courts. Justice Scalia in Maleska talked about, federal judiciary shouldn't be, usurping powers of common law courts. Common law courts, state courts should be doing that. And frankly, that could have been a good route. That's what state courts were doing for the first 200 years of this country's existence. I love this case from the Maine Supreme Court in 1836 called Merriam versus Mitchell, right? And there you have a postmaster, Nathaniel Mitchell. He got overzealous investigating missing mail. He falsely accused his assistant postmaster, William Merriam, of stealing it and filed a criminal complaint. And then Merriam sued Mitchell for malicious prosecution and got damages awarded to him. So because this option was available in state courts, the question in Bivens itself in 1972 was very much whether federal courts needed to provide an additional remedy to the one already available in state courts. So great. You can enforce it in state courts, individual rights, supposedly. But then in 1988, everything changes, right? Congress took away the option through the Westfall Act to sue federal officials in state courts, for state courts to exercise those common law powers. through the Westfall Act, Congress made the Federal Tort Claims Act an exclusive remedy against federal officials. So if state courts are no longer an option, if Congress is an institution beholding to the majorities and kind of has a conflict of interest, then the only other option is federal courts. And ironically, you do have a congressional authorization for this. The Westfall Act itself that took away the ability to sue in state courts specifically has this exception for civil actions brought for a violation of the Constitution of the United States, right? So it carves out constitutional claims, and it was passed in 1988. Justice Alito in Hernandez says, Congress left Bivens where it founded in 1988. But in 1988, Bivens was much more than it is today, and much more than it was with Ziegler versus Abbasi when the courts started to first drastically chip away from Bivens. But even if you don't have a congressional authorization, the question then becomes, why do you need one? After all, we already have a statute that provides federal courts with subject matter jurisdiction to hear constitutional claims, right? We all know that section 1331. District court shall have original jurisdiction under the Constitution. Importantly, the statute was passed in 1875 with the writ system still governing common law actions. And the meaning of the word jurisdiction at the time encompassed things like cause of action and like remedy. And I'd like to point you guys all to Professor Michael Collins's article called Economic Rights, Implied Constitutional Actions and the Scope of Section 1983. And he kind of talks about this period where after, 1331 was passed, that courts didn't use Section 1983, didn't look at it as a necessary prerequisite. And federal courts looked at the 14th Amendment under the Constitution and enforced individual rights that way. So that's important to keep in mind too, that not only is there a congressional authorization, you actually do not need one. And finally, of course, there is this point about damages as opposed to equitable remedies, right? We do have a case in 1907, Ex parte Young, and the courts have no problem implying equitable relief under the Constitution, but somehow they're having a hard time with damages. The bottom line is that federal officials are now entitled to absolute immunity post Egbert. And it is really weird, especially because you can still sue state and local officials in federal courts for violation of federal Constitution. And let's not forget the big picture. Again, the Bill of Rights is meant to be enforced. It's not an empty promise, but we are left in this unsustainable position. There is a right under the Bill of Rights, but there is no remedy. You can't go to state courts. You can't go to federal courts. Congress did speak through the Westfall Act, but somehow it wasn't enough. In the end, it is the individual whose rights are violated who is left to carry the cost of the constitutional violation. And in all this discussion, I want us to not forget that seems really strange that there is a class of officials who happen to work for the federal government who are absolutely immune. And the rest of officials, like state and local officials, while they do have a protection of qualified immunity, just like federal officials do, they actually can be sued for violations of constitutional rights. Thank you.
Oh, well, thanks very much. That was really insightful. John, I'll turn it over to you.
Thanks, Anya and Marc. It's a pleasure to be here with you today. I'd like to go back about how the court came to the test today. If you look at the two opinions in this case, they both say that the test announced and changed in Egbert comes from a two-part test. But I think that might be a bit of an inaccuracy. If you look back into Wilkie 15 years ago, the court actually applied a three-part test to decide whether somebody could bring a Bivens claim. First, did the Bivens claim arise in a new context? Second, if it did arise in a new context, were there any special factors counseling against implying a Bivens right of action? And third, were there any alternative remedies that were available to the claimant. Then 5 years ago in Abbasi, the court changed that into a two-part test. And it just became, one, is this a new context? And second, are there any special factors that weigh against implying a Bivens cause of action? Now, in Egbert, Justice Thomas announces a kind of new test, which he says everything boils down to just one question. Is there any reason to believe that Congress is better suited than the courts to provide for a cause of action here? So you see, as Anya said, this narrowing of the Bivens cause of action to where essentially it is a dead letter. It's going to be very hard, if not impossible, to bring a Bivens cause of action. There was much discussion at oral argument about the level of generality that the court should look at in this case. And the court took two different paths. On the first question of is this a new context? The court took a very granular approach. If there's virtually any fact that's different than the three prior situations the court has recognized a Bivens cause of action, then it does arise in a new context. But then when you get into, are there any special factors that weigh against the court implying a Bivens cause of action? The court looked from a very high level into whether there is a special factor. In this case, the court found that on the Fourth Amendment claim that there was a special factor about national security and border security. Justice Sotomayor in her dissent says, well, this actually didn't involve the agent enforcing border security laws because the individual from Turkey had arrived and went through port of entry in New York and then flew to Seattle and was driven up to the Smuggler's Inn. However, Justice Thomas says that's not what you look at. What you're looking at is whether allowing suits against Border Patrol agents, end of story, is a special factor. And then citing the Hernandez decision from a couple terms ago, it said, Justice Thomas said, yes, this does implicate national security concerns when you're interfering with Customs and Border Protection's job of defending the border. He also says that the enforcement of the immigration laws within the United States actually might be more important to national security than enforcement of those immigration laws at the port of entry. So what you have is that you have two different levels of generality that the court is going to look at when deciding whether to imply a new Bivens cause of action. First, they get very granular, and then they get a very broad-based view of whether there is a special factor counseling against this. And the same was true in the First Amendment context. It wasn't so much whether, and this is where the court was unanimous that Bivens should not be extended to the First Amendment retaliation claim. And that was because it would allow for these suits against any federal officer for allegedly retaliating on First Amendment grounds. And there's really no barrier to an individual saying, well, I did this action and then you retaliated against me. And that could be a Border Patrol agent, a FBI agent, or a U.S. Marshal. And so because those are so hard to dismiss, as Justice Thomas noted in the majority opinion, at the summary judgment stage or even the motion to dismiss stage, it's almost always going to go to a trier of fact. That would severely disrupt the executive branch's enforcement of the law. And so therefore, the First Amendment retaliation claim should not be recognized under Bivens. And I'd like to briefly respond to what Anya said about the policy implications of this, because I agree with her completely, like I said, that this is almost a complete overturning of the opinion. And Justice Gorsuch, I think, is correct that there's no reason to give false hope here. If you're going to overturn the decision, you might as well do so. But I think the court is just taking a step-by-step approach, and kind of like what they did in Janus to overturn past precedent, and what they arguably did in Dobbs with Whole Women's Health v. Hellerstadt. And so I think that we'll see Bivens overturned eventually. But the reason I think that's the correct way to go is because of the separation of powers. We are not living in the time where federal courts have a common law. The areas of federal common law are very narrow. They include for things like admiralty, which are specifically stated in the Constitution as belonging to the federal courts. Federal judges are not in the place to be making laws. That is Congress's job. And although Congress is elected by the majority, that doesn't mean that they're not the ones that are responsible for enacting laws. We shouldn't have unelected federal judges who have life tenure being able to get up there and say, well, this is what I think the law should be, and so therefore that's what the law is in this area. That's not how our constitutional structure was founded, and it's not how it should be today. And that plays a big role in Justice Thomas's opinion here in Egbert. He focuses on the separation of powers and talks about how Bivens and the two cases that followed that which recognized claims for sex discrimination by a federal employee against a congressman, and also deliberate indifference to a prisoner's condition, medical condition, that came in a different era where the question was, as Justice Kagan said, what was the purpose, purposivism, and not what the text of the Constitution or the text of a statute said. Ever since Sandoval especially, the court has shied away from acting as a lawmaker and has respected the separation of powers. There's another case this term, Cummings v. Premier Rehab, where the court reaffirmed that and said, it is not the job of the courts to come in here and imply a remedy for intentional infliction of emotional distress under the Rehabilitation Act. And although this opinion doesn't cite Cummings, it comes from that same area and cites the same cases like Sandoval and also like Hernandez and Abbasi, in saying that it's Congress's job to make the laws and not the court's job. Now, Anya mentioned when 1331 was passed and how that the word jurisdiction there had a different meaning. But again, that was in a different era because that came before the court's decision in Erie. And so there was federal common law back in the 19th century. And so it might have been more, I don't want to say it was more appropriate, but the understanding back there was that federal courts had this common law power, but they don't have that federal common law power as the court has recognized more recently. And it's under that backdrop that we have to look at whether the court should extend Bivens to a new context. And as Justice Thomas and Justice Gorsuch say, the answer is clearly almost never, that Congress is almost always in a better position to recognize a cause of action for a violation of the Constitution and not the courts. There are important policy considerations, for example, and you actually see that in the Westfall Act. The Westfall Act was in response to a court decision called Westfall, a Supreme Court decision, where Congress said, hey, court, you're overstepping your bounds in allowing these causes of action. So we're going to step in and pass the Westfall Act to tell you, get back in your lane. And that's where the court has gone kind of since the Westfall Act. You see it more in the past 25 years. But for the past 42 years, the court has considered 12 Bivens cases. They have not recognized a single extension in those past 42 years. So they recognized 3 Bivens causes of action in the first 10 years and none in the past 42 years. That shows how important the separation of powers is now to this consideration of whether to imply a cause of action under the Constitution. Now, as a policy matter, I think that it very well might be appropriate for Congress to provide for causes of action under the Constitution by either amending the Westfall Act or amending Section 1983 or both, so that claimants could bring a cause of action under state common law, for example, assault and battery in this case, because Agent Egbert allegedly, threw Boulay up against his car and then threw him to the ground. If you want to allow a common law cause of action there, that's fine. But that's for Congress to make that difficult policy analysis, to do the research and the balancing, and not for an unelected federal judge to do.
Well, great. This was really illuminating. I think it's fascinating that both of you agree with at least the analysis in Gorsuch's concurrence. Obviously, Anya would have reached a different result, but both of you essentially said that Gorsuch was correct in saying basically the court's dancing on the head of a pin. And in fact, apparently, of course, one thing that was mentioned is the Narcotics agency no longer exists that this agent was working for. And so that's a slightly different context that was referenced, although certainly that's not the only thing that was relied upon. But we do get into these very prudential determinations under the standard that is, as both of you said, virtually impossible for a plaintiff to satisfy. One question I had for both of you is actually about the Federal Tort Claims Act, because that is an example of where Congress said you can sue the federal government, and perhaps this doesn't apply here for a number of reasons, that it has to be within the scope of employment of the federal officer, whereas, and this arguably, he went way outside the bounds. But could y'all elaborate on that? And also a related question that Bivens was decided in 1971, and is there an argument that Congress, by not acting contrary to Bivens, implicitly ratified it, which is, of course, that's a problematic argument, especially since you need 60 votes in the Senate, that inaction is agreeing with the court's decision, but still, it seems like something to consider.
Yeah, I'm happy to take this two-part question. So you are right about the Federal Tort Claims Act, and to a large extent, it holds the key here, right? Under the Federal Tort Claims Act, you can sue federal government instead of the federal official for torts, right? Westfall Act is an amendment to the Federal Tort Claims Act. And the Westfall Act is what takes away the ability for individuals to sue federal officers in state courts, that common law remedy that we had since the beginning of the Republic. And at the same time, the Westfall Act is giving the Bivens cause of action, is recognizing Bivens cause of action as an appropriate remedy. So your second point about Congress being quiet post-1971, it actually is not just quiet, it is affirmatively recognizing a Bivens cause of action through the Westfall Act. If you look at the text of the Westfall Act, it specifically exempts from the Federal Tort Claims Act civil actions that are brought under the Constitution of the United States. So, and Westfall Act was passed in 1988. At the time, Bivens was a much more robust remedy. So there is a really, really strong argument that Congress, not just strong argument, Congress did endorse constitutional causes of action. And again, I really want people to kind of have this big picture in mind of the structure, right? Where if a federal official violates your constitutional rights that the Constitution provides you, that the Bill of Rights provides you with, right? You can't go to state courts to enforce it. You no longer can go to federal court to enforce it. And there are a whole bunch of arguments like Congress hasn't authorized it, but Congress did authorize this in federal courts and took it away from state courts. So as a result, you have promises in the Constitution that cannot be enforced because everybody is pointing fingers at each other and saying that nothing can be done, even though things have been done. And I just want to briefly kind of address that argument about Sandoval, right? I agree that there is sort of this hostility about implied causes of action and very much originate from the Sandoval decision. But that decision involved implying rights provided in a statute by Congress, right? Here we're talking about rights not provided by Congress to us, rights provided to us by nature, right? Rights that we have coming into the Union. And we are, when Congress provides you with rights, it can take them away. But when it doesn't provide you with rights, I don't think that the same, it works the same way where you can say, oh, we're hostile to implied causes of action. But to come back to what you talked about, I think that Congress absolutely endorsed the Bivens cause of action. And the Supreme Court on many occasions has recognized that Congress did endorse it, including Justice Alito in the Hernandez decision.
Before going to you, John, I just want to mention, in addition to the questions, hopefully that our audience will have, I see one already in the chat, so folks can, and I'll go ahead and pose that in just a few minutes, so folks can go ahead and pose additional comments or questions in the chat. But John, I imagine you want to respond to that.
Yeah, first, I think that Justice Thomas, instead of relying on the Federal Tort Claims Act, actually relies upon administrative procedures that were available to Egbert in this case. So under federal statute and regulations that are issued by the Department of Homeland Security, any individual can file an administrative complaint against a CBP agent for their conduct. And then that is investigated, and the agency may take disciplinary action. And they did that here, where they investigated Agent Egbert for about a year, and they decided not to take any disciplinary action. And what Justice Thomas said in the majority was this was an alternative remedy that was available to Boulay. Now, it wasn't, Boulay argued that there wasn't a sufficient remedy, but as Justice Thomas said, it doesn't matter whether it's a sufficient remedy. It's whether Congress has decided that that's the remedy you get, and it's up for Congress to decide what remedy is available for a violation of the Constitution. And so that's where I think that there was much more briefing on this, especially in the Ninth Circuit, about these alternative remedies. And what Justice Thomas said was that it was an independent ground to deny expansion of Bivens is because there was this independent remedy that Congress had provided for. And so, again, under Wilkie, this was the third step of the inquiry. Now it's just folded into the special factors, the one thing about whether Congress is better equipped to do this. And what Justice Thomas says is that, well, clearly Congress is better equipped to do this. And the reason that that's better equipped is because they have provided for some type of remedy for individuals that want to do that.
Great. Well, I have another question, which is kind of going back to the roots of all this, which is, what sovereign immunity isn't specifically explicitly mentioned in the Constitution. Of course, our founders were very much reacting against the royal tradition on which sovereign immunity was based, that, the king couldn't be held accountable. But of course, John, you raised the separation of powers question, but is there an argument that the Constitution does not create absolute sovereign immunity for the federal government? And if so, how would you have a limiting principle to kind of avoid unlimited liability?
I think that it's clear that there is no absolute sovereign immunity in the Constitution. I mean, there is at least one provision of the Constitution, the Fifth Amendment, that is self-executing and provides for a cause of action against the government for just compensation for takings. I think that what you see in the Bill of Rights is a recognition shortly after the ratification that there was sovereign immunity baked into the Constitution. However, there was one exception that the founders wanted to build in there, and that was for takings. I just wanted to briefly also respond to what Anya said about Congress acquiescing to this decision in Bivens. Congress didn't provide necessarily for a cause of action in the Westfall Act. It talks of the Westfall Act is dealing with where suits may be brought and who the suits are named against, but it doesn't say that you have a cause of action. And that's what Congress must do in order to provide for a cause of action. I strongly disagree with the assertion that any silence is acquiescence to the court's decision, whether that be in a Bivens or in other contexts. Now, I know Justice Scalia would disagree with that because he disagreed with it in the Title VI context, where he said that Congress's silence and then later passed statutes acquiesced to the court's recognition of a private cause of action under Title VI. And he also did so in the Bivens context. But in my opinion, just silence doesn't provide for a cause of action. It just means Congress has decided that it can't act, that it doesn't have the votes necessary to provide for a cause of action.
I'd just like to briefly mention the Westfall Act thing in terms of cause of action. So essentially what Congress is doing in the Westfall Act, where it's saying paragraph 1 does not extend or apply to a civil action against an employee of the government which is brought for a violation of the Constitution of the United States. What Congress is doing there is essentially recognizing Bivens, right? It's basically saying there is this court decision and we are saying that that court decision is all right. And that court decision, of course, is recognizing a cause of action under the Fourth Amendment. So at the very least, Congress is blessing Bivens, and that is how the Supreme Court has read it, including in cases like Huey versus Castaneda, where Justice Sotomayor specifically talked about this, and then in Hernandez, where Justice Alito talked about it. So I would disagree with John in terms of Westfall Act not being sufficient to provide a cause of action. By recognizing Bivens, it is essentially endorsing cause of action that was recognized in Bivens.
Well, let me now pose a question in the chat that came from Ishan Prasad to our speakers. He asked, could the statements in Egbert, which discuss why allowing retaliation claims would bring about spurious lawsuits, not be seen as weighing the impacts of policy, which is the job of Congress? The court attempts to reaffirm the separation of powers in Dobbs and Egbert, but ironically, they are weighing the impacts of policy, which is typically the job of a legislature, to phrase it as Alito did in Dobbs. I'm a little worried, no pun intended, about smuggling abortion into this, but go ahead and if either you would like to comment on that.
Well, I think that's the point, is that this is weighing policy considerations, and that's not the job of the court. And the last teleforum that Anya did with Aaron Hawley, there was a brief discussion on this point, and Judge Strauss, who was moderating that, talked about how he doesn't feel, as a Court of Appeals judge, that he's capable of doing these policy weighing and deciding whether to allow a certain cause of action to continue. But what they're doing here is just looking at whether there's a special factor and saying, because you have to weigh these policy considerations, that means it's better for Congress to do it, because Congress might come to the conclusion that it is appropriate to allow these types of suits for First Amendment retaliation. But because there are these policy considerations, that's not a job for a federal court.
I don't think you can call doing the job of the judge by judging a policy, right? What they're saying here essentially is that they can't look at a regular excessive force claim, right? Justice Gorsuch is talking about, an American citizen argues that a federal law enforcement officer violated the Fourth Amendment in searching the curtilage of his home. That's like a very, very typical thing that judges are used to be involving in. And all of a sudden, they're calling the act of judging policy. I would refer everybody to Justice Story and his decision in the Apollon, right, where he says it is up to the judges to look at whether the law was violated and then order appropriate remedy if it was. It is the job of the judiciary to judge. It is the job of the judiciary to look at an excessive force claim and say whether the excessive force was committed. And then it is up to Congress to calibrate policy implications. So just because you call the act of judging policy doesn't actually mean it's policy. And what Justice Thomas is doing in Egbert is very much calling the act of judges doing policy. Sorry, Mark, we can't hear you.
Can't hear you. You're on mute, Mark.
Sorry about that. We've got a couple of questions that I wanted to get to from our audience. One of them, why does Congress get to decide whether we can enforce our constitutional rights? Isn't that anathema to the very purpose of the Constitution? John, I guess your answer would be that it's a separation of powers question, but do either you want to tackle that?
I actually think if you want to read the other question too, Marc, I think that they go together.
Yeah, no, this one is interesting. Why does the court require a statutory cause of action for damages claims against federal officials, but not for injunctive relief, which arguably is more intrusive in terms of the impact on policy than damages?
And the reason I think these two go together is because you can enforce your constitutional rights through a suit seeking injunctive relief. So
how do you get in an excessive force case? Sorry, I'm just. How do you get an injunction for a cop to not beat you up in the future?
I mean, I do think that you can get policy changes and things like that. I mean, point well taken, Anya, but I think there are certain constitutional rights that can be protected by seeking injunctive relief. But the reason that you can't go and seek money damages and why Congress should be able to do that is because of the separation of powers. It's for Congress to decide whether to waive sovereign immunity, and it's for Congress to decide whether there is a private right of action against an individual and not a public right of action. Justice Gorsuch talks about that in his concurrence here, and he's been talking about it for many years, that when you're creating these private causes of action, it's for Congress to do and not for the courts.
And I just want to kind of go back and emphasize that, you know, it wasn't as big of a problem in the first 200 years of this country's history because we could go to common law courts and enforce our individual rights under the common law, right? That was a very important thing to do. And there was an accountability and there was living up to this promise of where there is a right, there is a remedy. But all of a sudden, you no longer can go to state courts since 1988. And the federal courthouse doors are close to you as well. And the result is very much that you have the Constitution, a lot of which can only be enforced through damages. And you have courts telling you, too bad, you know, it's completely out of our power to do anything. And what you end up with is an individual whose constitutional right is violated and who can't turn to courts for remedy. And if that's, you know, not running contrary to originalism, I don't know what else is.
Well, both of you may agree that, of course, the size of the federal government and so the potential instances of such violations has obviously increased over the last couple of centuries. John, did you want to make another comment?
Yeah, I just wanted to agree that if you look at like the early days of the Republic, this was handled in state court. And if you look at mainly the cert stage briefing in Egbert, you'll see a lot of examples, for example, of like ships being seized and then the ship owner suing in state court to obtain relief for like an illegal seizure. And these claims were handled in state court, but Congress has made the policy decision again in 1988 that they don't want these cases handled in state court. And that's Congress's prerogative under the separation of powers.
Let me just, we have a comment here from Lawrence Joseph. He says there's a difference between ratification and simply getting out of the way. In the Westfall Act, HR 4612 would not affect the ability of victims of constitutional torts to seek personal redress from federal employees who allegedly violate their constitutional rights. I guess that's a quote from the congressional proceedings. And I guess a member of Congress said, I would like to emphasize that this bill does not have any effect on the so-called Bivens cases or constitutional tort claims. And he asks, is there room to say that, quote, no effect leaves Bivens where Congress found it up to the courts? The Supreme Court was willing in 1971, but not since the 1980s.
I find, you know, this, you know, statements of representatives or statements in committee reports like that. I just, if that's what they wanted to do, they would have passed it in the legislation. Just because you say it on the floor of the Senate or the floor of the House, if, you know, AOC gets up on the floor of the House and makes a statement about what a bill is going to do. That doesn't mean that's what the text of the act actually does. And you actually have to look at the text of the bill to see what it does and not what, a congressman wants it to do.
And I want to kind of point listeners and viewers to this kind of procedural thing with the Westfall Act cases and state courts, that some could technically say, if an officer acted outside of their scope of authority, then you can sue them as individuals in state courts, and you should be all right. But that generally not how it works, because, like in the case involving former President Trump and defamation in state court, the DOJ can always come in, issue a Westfall certification letter, and basically say, we are taking over the defense from here. So when we're saying that the state court's doors are shut, the state court doors are shut.
I know we focused on kind of the legal minutia, but this seemed like a good time as we reach the end here to ask each of you I think both of you would probably bet dollars to donuts. I certainly would, that Congress will do nothing. But if Congress were to act, what would you think the best regime would be? Would you have a cap on damages? Should we consider like a compensation fund so people can at least collect kind of compensation without the concern that protracted litigation, the costs of that, and getting into punitive damages and things like that, but just have an expeditious way for people that, for example, have healthcare costs that because they were injured and that sort of thing to be able to collect. But would both of you want to comment on what you see as like an ideal regime that Congress could pass?
Yes, amend Section 1983. Right? Just say employed by the federal government in addition to state and local officials. That's all you need to do. There is and yes, Marc, I agree with you. It sounds easy. That's all you need to do, but it's very, very difficult, especially since the court is refusing to explicitly say that it no longer allows causes of action under the Constitution. But if the court, if Congress were to simply pass a Bivens Act, and it was already introduced in legislature by Representative Hank Johnson and Raskin, right, that amends Section 1983 to include federal officials in there, then this whole debate becomes theoretical, right? And then federal officials are taken to exactly the same level as state and local officials. And then when you sue them, you still have to overcome qualified immunity. But at least there isn't this additional question of whether you have a right to sue federal official in the first place. And I would refer everyone to this amazing concurrence by Justice Willett in Byrd versus Lamb, where he says it sure smacks of self-dealing, right? When Congress passes a statute that says, hey, state and local officials, you guys go at it. Go ahead and sue them for violations of federal rights. But federal officials, let's not worry about it. I wouldn't say it's self-dealing. I would just put it back to its history, right? When the Ku Klux Klan Act was passed in 1871, you could sue federal officials in state courts, and it was not a problem. The problem was to bring state and local officials to comply with Reconstruction, right? And state courts provided bias fora. So federal courts were basically allowed to look at state and local officials' behavior. So at the time, there wasn't a concern with federal officials, but today there very much is a concern with federal officials. And the right thing for Congress to do is to amend Section 1983 just to add 3 little words and include federal officials into that accountability scheme.
Yeah, if you're going to do it, that's the cleanest fix, is just to amend 1983.
Okay, we have a couple of questions here that came up in our chat. One is, if Egbert had sued on the First Amendment theory while the retaliation was occurring, couldn't he have gotten an injunction and attorney's fees? How is that less of a separation of powers problem? Then the other one was, doesn't John's position on the Westfall Act render that language surplusage? What is a civil action against an employee of the government which is brought for a violation of the Constitution of the United States if there is, you say no Bivens?
So I think the first question on whether he could have sued while the retaliation was ongoing, I think he may have been able to sue the to stop the IRS audit possibly, but then there's the Tax Injunction Act, and there's other statutes that might have stopped that. I'd have to do some more research to decide whether he could have actually gotten an injunction. But assuming that he could have gotten an injunction and attorney's fees, the reason is as far as attorney's fees goes, at least, is because Congress has passed a statute that permits for attorney's fees. And so it's not something where the court is saying, oh, we're going to give you attorney's fees even though Congress hasn't authorized it. So again, it goes back to what Congress has and hasn't authorized when it comes to monetary damages. As far as rendering the language surplusage, I don't think it's surplusage. I just think it's a recognition that, Bivens was good law in 1988 when the Westfall Act was passed, but Congress decided that they weren't going to, quote, ratify that by passing a statute that provided for a cause of action for a violation of the Constitution. And instead, it went through all these machinations with respect to, who can be sued when the U.S. takes over in the defense of the suit and so on and so forth. That's different than providing for an actual cause of action.
Anya, did you want to comment on that?
Just going back to, John and I have a fundamental disagreement on what the significance of the Westfall Act is, and also the significance of the subject matter jurisdiction statute 1331. From my point of view, Congress twice allowed Bivens suits directly under the Constitution for violations of constitutional rights. And from my point of view as well, is that because Bill of Rights is an anti-majoritarian document, it is difficult to wrap your head around this requirement that an institution that is beholden to the majorities is the one that is allowing you to come to court and try to enforce your constitutional rights. That just, a lot of things in this world are common sense, and we're just getting ourselves lost in these very procedural weeds, which I am very happy to get into, and I'm always guilty of doing that. But I just don't want listeners to lose this big picture idea that somehow, because of this whole bunch of different excuses that we're coming up with, an individual is left with a right on paper, but no remedy. Post Egbert versus Boulay and post Supreme Court rejecting 2 petitions involving domestic policing, there essentially is no way to sue federal officials for violations of constitutional rights, for violations of individual rights, period. And that just, I don't think we can just throw our hands up and come up with a whole bunch of excuses. At the end of the day, it's individuals who are left carrying the burden of the constitutional violation. Although one thing I want to mention, and that's for going forward, is how easy it is to be classified as a federal agent. Marc, you mentioned that, federal government grew incredibly, right? And we have this unbelievable federal workforce. But in addition to that, you can get deputized as a U.S. Marshal. No problem, right? You can also get on a federal task force, no problem. And even if you are enforcing a state warrant, but you happen to be on a federal task force, federal courts will say that you are going under a Bivens regime rather than going under the 1983 regime. So given how easy it is to transfer between different employment statuses, right, from state and local official to federal official, I wouldn't say that if there is this absolute immunity loophole for federal officials, then 1983 is not safe either, because it's really easy, and we see courts are doing it all the time now, to just say, simply by virtue of being recognized as a U.S. Marshal, or simply by virtue of being on a task force, even if what you're doing is only related to state law, you still go under Bivens, and there is no such thing as Bivens. So too bad, 1983 is empty letter as well. So this is something I want people to pay attention to, because the 2-track system where state and local officials are treated one way and federal officials are treated another way is simply unsustainable, and eventually everybody will have absolute immunity.
Well, I really appreciate it. Unless either of you have something burning to add, I think we are about to hit the top of the hour. So we've had a really robust discussion, and I really want to thank the Federalist Society and the Criminal Law Practice Group Executive Committee that I serve on for facilitating this, because as I think everyone can gather from what we've been talking about, these are really weighty issues that will affect many cases for years to come. So with that, thanks again for joining us, and please check out the Federal Society website for future teleforums. And of course, this will be archived there as well as audio. So thanks so much, and I guess I will send it back to our host.
Well, thank you so much, Marc. And on behalf of the Federal Society, I would like to thank you and our panelists for the benefit of their time and expertise today. And I would like to thank our audience for joining us and participating, especially with those great questions. We welcome listener feedback by email at info@fed-soc.org. And as always, keep an eye on our website and your emails for announcements about upcoming webinars and other programming. Thank you all for joining us today. We are adjourned.